Looking around the room, can I just check how many people already have used an ombudsman scheme to help clients? So generally speaking, most of this side of the room, yes. This side of the room, nobody at all. So for the benefit of those people who haven't yet used an ombudsman scheme, those who have, just bear with me while I do a bit of an outline of what they do and why I think they're really helpful to clients who are in vulnerable circumstances. So I work in the Consumer Protection Unit, which is part of the civil section of legal aid, and we help people who have issues with credit, debt, insurance, door-to-door sales. Basically, if somebody's being ripped off, they can generally get advice and, in some cases, casework assistance from us. And one of the things that we use a lot are ombudsman schemes for essential services. And one of the major reasons for that is that ombudsman schemes are a no-cost jurisdiction. So unlike if you take somebody to court, where people end up having to pay costs if they lose, if you go to an ombudsman and lose, you're not at risk of having to pay costs. And when you're dealing with the types of clients that collectively we deal with, that's always a really important consideration, because one of the things you're always conscious of is you don't want to make it worse in the process of trying to enforce somebody's legal rights, because a lot of our clients don't have much to begin with, and you don't want to put at risk what they have got in the pursuit of what's right. So in that context, what I wanted to talk about today are the following issues. And for those who haven't used the ombudsman yet, I'll take you through the types of ombudsman that are out there and what they can do. Look at this idea of, well, do you have to go back to a company first to complain before you get to go to an ombudsman? And if so, how do you do it so that you don't vanish into the vast bureaucracy that some companies have? Thirdly, and we covered a little bit on this already, why are ombudsmen different from courts and why does that help us? Do you have options if you don't like the ombudsman? And then this is the one I want to spend probably most time on. What are the common things that our clients do wrong when they try to engage with the ombudsman? Because that's the sort of thing I reckon all of us collectively have a really important role in, and that's assisting clients to give voice to their complaints in such a way that it's the easiest for people who haven't been involved in it to understand. And then finally, a little bit of information about legal aid and why, and what assistance we can help you guys with and help your clients with. All right. So you may have seen in the news quite recently, the government's currently actually reviewing the financial services ombudsman as part of the various things that are going on in the banking industry. And the two main ombudsmen in that space are the financial ombudsman and the credit ombudsman service. Now, the background to why they exist is in order for anybody to lend, they're required as part of their license to be a member of one of these schemes. So contractually, if they're not a member, they can't lend anybody any money. And the really important bit about that is that what that means contractually, if somebody takes a complaint to an ombudsman and the ombudsman makes a decision in the consumer's favour in the financial services space, and the consumer says, yes, I accept it, the company is actually bound to accept that decision and has no choice but to follow through with what the ombudsman has ruled. And in a lot of ways, that's more powerful than what a court can do for vulnerable consumers, because often in the court scenario, you might have a judgment, but if somebody refuses to pay it out, you still have to go through an enforcement process in court. And in this space, people are much more likely to comply with an order if they've got the background knowledge that if they don't, they might be kicked out as a member. And if you're kicked out as a member of either of these ombudsmen, you run the risk of you losing your license to run your business. So in terms of a system that's very powerful and a system that can provide us a lot of great assistance to consumers, I think that's a pretty good one. And I should add, if people have questions along the way, I'm happy to for people to yell in my direction, and we can deal with them as we go. Similarly, in the telecommunications space, as was up there, there's also a telecommunications industry ombudsman that allows you to deal with phone complaints and most internet type complaints. And we see an awful lot of these amongst younger people with telephone issues, and I'm seeing nods around the room that suggests that everybody in the room sees something similar. People who get signed up to things asking for a basic phone, and they end up with bells and whistles at $150 a month when they can only afford $50. This is all sounding familiar. Yep. Again, telecommunications industry ombudsman provides that cost-free jurisdiction, which I think is really, really important, because again, if people are in that position and they can't afford it, they certainly can't afford to go to either QCAT or the courts to enforce their rights. Then, and a couple that I find are less known, but are no less important. And QCOS, I'm sure, does an awful lot of dealing with the Energy and Water Ombudsman. For the benefit of the webinar, QCOS are on the Advisory Council for the Energy and Water Ombudsman. And they play a really important role, because is it still the case that Queensland has the highest rates of disconnection in Australia?
Well, last year was the highest ever in Queensland.
Yeah, but okay, again, for the benefit of the webinar, QCOS has just confirmed for me that last year in Queensland, there was the highest number of disconnections ever in Queensland. So it's clear that's a really big ongoing problem. And anecdotally, I hear from clients, one of the things they really struggle with in this space is actually finding their way to the company's hardship and assistance areas. And again, I'm seeing nods around the room, that's a common experience. So the Ombudsman plays an even more important role in that sort of context for mine, because if you can't find where you need to complain to, you're often left with going to the Ombudsman to try and help you gain access, for want of a better word, into the company. Now, the final one I've got up on there is probably one a lot of people didn't know about. There's actually a tolling ombudsman to deal with people who have had incurred fines as a result of not paying tolls on the various toll roads that are now around mostly southeast Queensland. And we have seen people who have had to go to the Ombudsman owing tolls in the range of $20,000, $30,000, $40,000. And how it gets up that high is that if you don't pay with a single toll within 3 days, that toll attracts a first stage administration fee, and then if it's not paid, it attracts a second stage administration fee, and if it's not paid, it attracts a third stage administration fee in the range. And if you get through all of those 3 levels, we're talking hundreds of dollars in administration fees on a single unpaid toll. And if you have that across 20, 30, 40 unpaid tolls, you can see how the maths get you up into the tens of thousands of dollars pretty quickly. So that's probably the newest of all the ombudsmen, but I think particularly in southeast Queensland, that is going to take on more and more importance, because it's an issue, particularly in suburbs of lower average income who are around these toll roads and may feel they have no other option but to use the toll roads in some instances. So in that context, what we now want to go into is, okay, what's the process you need to do before you can get to the Ombudsman? And is there a difference between internal and external dispute resolution? So external dispute resolution is when you get to go to the Ombudsman. But there's a prerequisite before you can actually get into the Ombudsman. And that is, you're supposed to make a complaint to the internal disputes area of the company you're complaining about. And they sit, in theory, and to be fair, they are, as an independent little group within a company who are responsible for reviewing the decisions the company has made. Now, when you interact with these companies, you will encounter a wide range when it comes to the effectiveness of internal dispute resolution companies. Some are fantastic and very responsive and listen to the issues you're raising. Some are less good at exploring the issues you've raised about how the company has behaved. And so what I tend to find is you generally get a lot of issues resolved at internal dispute resolution when they have a good process, and you tend to end up having to take a lot of complaints to an ombudsman when they have a bad internal dispute resolution process. But I guess what you need to work out is what's the sort of things you need to be aware of in that internal dispute resolution process that might put you on notice that the process is either good or bad. And one of the things we often encounter that says not such a good process is what I call multi-tiered internal dispute resolution. And that's the sort of thing you might encounter where if you complain to the internal dispute resolution and they'll say, yeah, we've had a look at it, we don't think there's anything into it, but we're going to refer it to our manager to have a look at it as well. And then the manager will say, I've had a look at it, but I'm going to refer it to my senior manager so they can have a look at it as well. And you feel like you're never going to escape the 14 levels of bureaucracy that that particular unit might have. Some grins around the room saying they've experienced that. Am I being unfair when I say 14? Probably. We're probably talking 3 or 4 levels is the most I've ever seen, but that's too many. And the laws set up that if you make a complaint to internal dispute resolution area and one person has reviewed it properly and made a decision, that's enough. The law actually only gives companies one crack at internal review. And if they don't do it properly or don't respond appropriately, that's enough, and that triggers your client's ability to take the next step, which is to lodge an ombudsman complaint. And that's really important because you don't have to sit within that company for forever before you can go to an ombudsman, and nor should you, because a lot of our clients' complaints that they're bringing and difficulties that they're bringing are really important and are often time sensitive and require a resolution within that time. So it's important you recognise that when a complaint might be being stuck and move it on to the external ombudsman as appropriate. Sometimes, and I'll admit this, sometimes you reckon you just ended up with the wrong person in the internal dispute resolution process and you now think the right person's got it. And I will often hold off in that case for a week or so to give that right person the opportunity to try and fix it. And that will sometimes work. But that's a judgment call for you guys on the interaction you have with them at the internal dispute resolution area. Because sometimes you'll know when they're genuinely trying to help, as opposed to when you feel like you're being strung along. And we've all had both experiences, I'm sure. The second thing I would say is be aware if there's court action threatened. Because if there's court action threatened and the court action starts and there's no ombudsman complaint, your clients actually lose a lot of rights in the ombudsman. Because a lot of the ombudsman will have clauses like if court's already started, they can only look at particular issues, which might not be your client's issues. So one of the advices I always give if court action is threatened is one of the things you can do as a client to protect your rights, assuming you do have a valid legal argument, is to lodge an ombudsman complaint, particularly in the banking and financial services space and telecommunications space, that if you do that, the company can't take an enforcement step, and that includes starting court action while the ombudsman reviews the complaint.
Is that even if you haven't put an IDR in?
I would do that even if you haven't put an IDR in, because the ombudsman will acknowledge the complaint, register it, and then return it to the company's IDR to have a look at. And why that's important rather than just going straight to the IDR is, in theory, if something's with an IDR area in a company, they can still start court action even though the internal disputes area is looking at it. Not many companies operate that way, but in terms of me giving legal advice to a client, I've got to give them all the information about, well, what will protect your rights legally. And in that space, that's what protects their rights legally. Any questions about that before I move to the next? All right. Now, I covered a little bit of this earlier. Why are ombudsmen different to courts? Big one is the costs issue. And as we know, court action for most of our clients is not something they could ever even dream just about starting. They've often had less than okay experiences with courts in other legal areas, and so probably aren't hugely trusting of the court system, whether that be right or wrong. That's just the attitude my experience is some of them have, and that's okay. Ombudsmen offer that alternative, which is not going to cost them any money and still allows them, if it doesn't work out, to take up that option of going to court. The other improvement on court for mind is that ombudsmen are often able to look at what is fair and reasonable in all of the circumstances, given the law and good industry practice. Now, when you compare that to what the court's allowed to look at, big difference in terms of what a client can access, because the court, quite rightfully, looks at the law, decides it on precedent, has less scope for being a bit creative as to what will actually practically solve the situation. And what I tend to find in the ombudsman, because they can look at what they believe is good industry practice, what would be a fair result in the circumstances given what the law is, you often see results that, rather than being 100% one way or another, are often a meeting of the joint bad conduct that can often occur from both a client and a company in their dealings. Because I think it's probably fair to say that when things go wrong in this sort of relationship between a client and a company, it's rare that one party is completely blameless. It will happen, but often, because of the circumstances the client are in or because of the behaviour of the company, you have a situation where the right result is often both parties bearing some responsibility, and that should be reflected in the resolution. And that's something that I think ombudsmen are good at in terms of reaching what's appropriate given the circumstances, and have more scope to do that than often the courts do. And then thirdly, and this is the one that clients are often less sure on, these ombudsman schemes are set up to try and allow clients without or the ability of a lawyer, or who do not have the access to a lawyer, to run the complaints themselves. And that's really important, because the reality is, and I'm sure you guys have encountered that, there's not enough free community lawyers or legal aid lawyers in this civil and consumer space for people to get easy access to it. It's actually pretty hard to access, because in my space at least, I think might be 5 of us in the state across CLCs and legal aid who do consumer credit and debt on a full-time basis. So part of this is, and we're always keen to work with you guys on this, is sometimes by us having a 5-minute conversation with you guys, we can give you enough to say to the client, this is what you need to say in the complaint, lodge it, and if they ask you questions you don't know, come back to us and we can talk to you again. And that way people aren't put to the stress of having to fill out a lot of paperwork to get a lawyer, when we can do it in a way that I would argue empowers the clients we're dealing with a bit. It's not always the case that you can do that, because some clients will still need the hand-holding and still need the help. But where you can empower a client who's not had a good experience with the system to access the system and get a result, I find that actually can often have flow-on effects to other areas of their life, because they remember that they can do it and they do have the power to do it. And I think that's a really important thing too, to remember that you can access your legal rights and you can have your issues heard against companies you believe are more powerful than you. And I'm sure we've all had discussions with clients who say words to the effect of, why am I doing this? They're going to win anyway because they're big and they've got lots of money. And one of the really strong things for me about the Ombudsman is it does a good job of addressing that perceived power imbalance. And I think that's really, really important. All right. The other good bit I like about the Ombudsman is that if a client doesn't like an Ombudsman determination, they actually don't have to accept it. It's not binding like a court. But if they do accept it, they're then bound by it, the company's then bound by it, and they can't go to court. And that's really important. So if a client gets an offer from a company as a part of an Ombudsman complaint, it's really important they consider that really, really carefully, because if they say yes, that's all their legal rights go on that particular issue, and they can't re-enliven it. So that's both, in a way, that's a positive and a negative, because it gives people some finalisation, but they've got to be sure it's a result they want. Because if they change their mind 6 months later, they can't go back and reopen it. Having said that, and there's always two sides to every coin, what if they don't accept it? Fine, they can go to court, but that also means the company's allowed to go to court as well. And what you often see is people who reject an Ombudsman complaint, and we see them 12 months down the track saying, the company's now got a judgment against me, what can you do? And the answer often is nothing. Because if it's progressed to such a stage where a company has a judgment in court, the debt's probably increased by 5, 10, 15 grand in court costs and interest by that stage. And to set a judgment aside, you need a really good legal reason, such as you weren't even served with the court documents or something really serious has happened. And my experience in the Queensland courts is it's actually really, really hard to set a judgment aside. Does that reflect, I know there's some lawyers in the room, that reflect your experience as well? Yeah, I'm getting some nods. That reflects the experience as well. And so it's really important that when you can deal with these issues as soon as possible in the process, generally speaking, you're always going to get a better result for the consumer than if the consumer's coming at death's door when the court proceedings are nearly done. I know that's me being in a utopian world, and we were always going to see clients at that end stage as well. But if collectively we can get that advice earlier on in the process, I think that's really, really important. All right, now I want to talk about common errors in Ombudsman complaints, and this is probably would apply to common errors in court as well. One of the experiences I have with nearly all clients is they feel very wronged by the company they're complaining about, and it's impacted on their lives quite greatly, and all of the focus is on it's wrong, they've been terrible, do something about it. And that's perfectly okay, because we're all human and we all get emotional and we all hate it when we feel like we've been wronged. But one of our roles, I think, collectively, is to help that client tell their story. And sometimes this is really hard, but if we can get them around the idea of, okay, what happened? What did they say? What did they do? What did they say they would do but didn't follow through with? Those sort of questions set up, well, what is it we're saying that the company did wrong or didn't do properly or didn't do as they said? Because if you start with that context, then you can have a conversation with the client, okay, this is what they did. What happened to you as a result? Because in the Ombudsman and in courts, it's very rare that a legal issue is going to be decided on hurt feelings or the emotional damage that it's done to somebody by the conduct. What the focus is on is how has that company wronged or not wronged the person by the actions they've done. So that's step one. And then step two is, okay, how has that affected me? And if you can move the clients to that point, what I tend to find is the results you get out of the ombudsman are often quick, and often see the company resolving the dispute before the ombudsman's made a decision. Because often what happens is that the relationship has broken down so much between the company and the client that even where the company is trying with their best endeavours to try and work out what the complaint is, they can often struggle to work it out. And if you can help the client articulate that in such a way that doesn't have as much emotion in it and focuses on what happened, I tend to find a lot of companies are good at then coming up with solutions that might resolve that problem. It's a lot harder for all of us collectively if we can't get at the actions and the conduct that lies beneath that emotion. And that happens, that makes it hard for you, it makes it hard for me, it makes it hard for the company, it makes it hard for the ombudsman if it gets that far. So that's really important. The other conversation I have an awful lot is around setting expectations. Nobody is going to become a millionaire because the bank has hurt your feelings or you've been inconvenienced or anything like that. It doesn't work like that, will never work like that, and should not work like that. Because what this is all about and what courts and ombudsmen are all about is putting people back in the position they were in had that wrongful conduct not occurred. And the classic one I often have is somebody will come, they can't pay a mortgage, they bought a house with a mortgage, and the starting point is, well, they shouldn't have given me the loan and I want to keep my house. Not going to happen. And the reason that's not going to happen is the only reason you're able to get the house was through the bank giving you the loan that you say they now shouldn't have given you. So if we're putting somebody back in that position that they were in had the loan not have been given, that's usually the house being sold. And if there's a shortfall on the loan, us having an argument in the ombudsman about whether or not that client should be liable for the shortfall on the loan. And the argument would be if they shouldn't have been given the loan at all, the company should wear that loss. Sometimes I win that argument and sometimes I don't. But that's the sort of argument we're talking about and why it's important to set expectations. And linked to that is this idea that has the client got a benefit from what's happened? And in that space, the classic for me is when somebody takes out a loan or a credit card and then they say, well, I can't afford to pay it or they shouldn't have given it to me. But they've used some of the money to, say, buy white goods or buy a car or do something like that. And in that context, there's a clear benefit that they've obtained, even though they say they shouldn't have got the money. And sometimes it can be tricky to put a value on that, but I think that's always a really important discussion because I think all of us in society think it's fair that if you've got a benefit from something, you can't then double benefit by saying, oh no, I shouldn't have been given it at all, without that benefit being taken into account. And sometimes that's hard to judge and requires a bit of negotiation and a bit of deep thinking, but I think that's the fair result in the circumstances, and that's often what you see in the ombudsman. But it's often a discussion you have to have really carefully with clients because, again, the focus is on I've been wronged, and that's right. But you've also got to look at what you got out of it as well, and have that balanced discussion with clients. And that's a discussion that sometimes can go terribly. And go really terribly, but it can also go very well. And when it goes very well, it solves things very quickly. When it goes very badly, it can be a long and involved process. And again, the grins around the room tell me that we've all been involved in the long and involved processes sometimes, and that's okay, because they're exactly the clients we should be helping, who need a bit more help to understand what's happened and why. The final thing that I often have a lot of discussions with clients about is you can form a legally binding contract without actually signing something. Classic is the phone, where they read out to you the seemingly endless privacy message that goes for, it feels like hours, but it's probably only a minute or two. and then say, do you agree? That's a contract. My experience is a lot of the clients we deal with don't understand that that's a contract and keep asking the company for the signature. Where did I sign? You're not going to get it if you've signed up in that context. By the same token, those phone recordings are really important, and I'll often ask for copies of them, because they'll often reveal whether the company has been totally upfront about what a person signed up for. And I have both won and lost cases, it's quite spectacularly both ways, on the basis of what was in those phone recordings. Because the reality of us as human beings is we're very good at remembering what we want to hear and not necessarily what was said. And that goes both for the people signing up and for the company trying to sign people up. And it's only by going back to the source you often get a true picture of what's happened. Sure.
We do primarily, well, I know people that come from a non-English speaking background,
Yep.
refugee background, so
Yep.
don't mind if they're not understanding necessarily the systems. How does that work? Because often they're on there, blah, blah, blah. Yes.
Yeah, and the question I describe is around what I call a passive yes, where if somebody doesn't necessarily understand what's being said to them, but because they want to fit in, they'll say yes anyway. And they'll say yes to whatever's being said without understanding what it is and how it's said. And my attitude around passive yeses is they're actually really easy to spot on phone calls. And if it's really clear there's a passive yes, that contract for me is very rarely going to be valid, because contracts, after all, are about a meeting of the minds and an understanding this is the service I'm getting and this is the service that's being offered, and the two of them are the same thing. The second issue I'd have there is if they're not English speaking and the company was aware of that, if they want that contract to be valid for mine, I'm going to want an interpreter being involved in the call. And if they've chosen not to get an interpreter involved in the call and the call doesn't go the way it should, for me that's the company's problem. And they should, if they want those contracts to be valid and they want to be certain people are understanding, they should be having an interpreter read that contract out.
Is that likewise in store from an offline, for example?
Look, in a lot of ways, and I know there are companies out there that disagree with me on this point quite greatly, but I'll put my point of view. To me, it's often even more obvious in store when an interpreter is required, because you can look into the eyes of people, and I'm sure everybody in this room knows when somebody's understanding and when they're not, when you're talking to somebody face to face. And if you're getting that vibe, or you're getting that appearance from the way they're conducting themselves, or the fact that they're clearly not understanding, you should be doing something about that. And if you don't, you'd want to have a really good argument as to why that contract's still valid. Because if you don't, I'm arguing you haven't done your job. Again, I will win some of those arguments and I will lose some of those arguments, but I think it's an argument often worth making. Now, to close, a lot of you, there are people in this room who I already talk to on a fairly regular basis, which is good. As a consumer protection unit, we do give advice. We have advice sessions every day on the phone, and then we have face-to-face advice sessions for clients at the moment in our Woodridge, Ipswich, and Inala offices, and hopefully looking at expanding that to some of the other offices in the near future, because we find they're working very well for the more vulnerable clients who might struggle with a phone. And obviously the more we can do that, the better. We also offer, and this I should add is just the consumer protection unit and only the consumer protection unit. If community workers wanted to call us with a question about, is this something legal I can help with, or this is what we do, or I've got this client with X, what should I do? I and my colleagues, Catherine and Loretta, are happy to receive those calls, because we find we often know the answer in a couple of minutes, and it might take you guys 15, 20 to find it. And if we can cut down on and save everybody time, that's a good thing. So please take advantage of that. If somebody doesn't have our phone numbers, I'm sure we're happy for that to be sent out. But if it's an individual client, as I'm sure this number's appeared a lot already today, that's our call centre number to ring and book for an advice appointment in areas across civil, family and criminal law. Our call centre client information officers are fantastic in the sense that they are across all areas of law and the appropriate referrals in all areas of law. Me being me, some days I struggle to be across just mine. They're across all three every day. And if it's not legal aid, they're really good at referring a client to the appropriate place. So often, if you're not sure where to go, it's often all right to give them the call centre line because you know that they'll get it referred to the appropriate place even if it's not legal aid.